Hello everyone, and welcome to our next lesson where we're going to be talking about the role of the Victorian courts in civil cases and the court hierarchy. We're going to go in depth into basically the jurisdiction of each court in civil cases, so the amount of damages they can hear up to, if there are appeals that are heard in one court, where they end up going to, and then overall the purpose of those courts and what they're trying to achieve in civil cases. So as we mentioned in previous lessons, in any civil case, we're always trying to resolve that case before we get to court. That's why we have those alternative dispute resolution procedures, as well as the tribunals, ombudsman, and complaints bodies. So let's get right into it. We're going to talk about methods that are used to resolve civil disputes, such as the courts, not tribunals. That's totally wrong. This is don't trust that. But the role of the Victorian courts. So one of the things they do is determine liability. So we're not determining guilty or not guilty in civil cases, we're determining if someone is liable or not liable. So courts decide whether the defendant is liable based on the balance of probabilities, so it has to be most likely. And in this way, the court acts as the decider of facts. In determining liability, the courts apply strict rules of evidence and procedure, and courts will manage the case before it reaches trial. So once again, when we say the balance of probabilities, it's all about who's most likely to be right in that case. And that's really important in civil cases. The reason it's not beyond reasonable doubt is because sometimes the evidence is a little less clear-cut in a civil case, and it becomes a little bit of basically arguing who's the most correct in a situation. And so deciding on the remedy, if the defendant or plaintiff is liable, courts will decide on a remedy, and damages in the form of money is the most common remedy. We also have other ones like an apology or injunctions, etc., but we'll get into those in more detail in future lessons. So, the jurisdiction of each court. So, our court hierarchy in order is our magistrates court, the county court, the Supreme Court, trial division, and then the Supreme Court, Court of Appeal. And it's always really important to remember that order. But for the original jurisdiction of each. So, when we've got the magistrates court, so let's just say we had a case. So, if we have props, if we had a civil case where Batman is suing the Joker for negligence and he's suing him for $80,000, that would be heard in the magistrates court because they hear claims of up to $100,000, and if it's less than $100,000, or if it's less than $10,000, it goes straight through arbitration. So the magistrates court is the lowest court in the court hierarchy and has no appellate jurisdiction. So I really recommend having this table somewhere, like copying it down, copying and pasting it into your notes somewhere. It would be very useful to have. Whereas then the original jurisdiction for the county court is unlimited. In some cases they say up to $500,000. I tend to kind of lean towards that when saying things like this, because sometimes you're given a case and you're asked which court it's going to be heard in. So on the lower end of the scale, that's above $100,000 but below $500,000, I tend to say the county court, because then it ends up being, it's just a way to differentiate between this and the Supreme Court, which also has unlimited jurisdiction. So, and the county court also has no appellate jurisdiction unless specified by an act of parliament, which is a really niche reason for an appeal to go there. Supreme Court trial division is unlimited, and here's appeals from the magistrates court or VCAT only on a point of law. So this is when the law hasn't been applied correctly, it goes to the Supreme Court trial division. And then the Court of Appeal has no original jurisdiction. However, it hears appeals from the county court or Supreme Court on a point of law, questions of fact, or the amount of damages. So if we had two people again, so if we had Batman and the Joker, and Batman sued the Joker for $80,000 in one, and the Joker felt that was not fair, he could appeal it. It would go to the Court of Appeal, where he could then try and recoup some of those damages. However, if he's incorrect, the damage is probably going to be more, and he'll be out more than $80,000. In other situations, it would be in this negligence case, if the law was not applied correctly, they could appeal, and it would go to the Supreme Court trial division. I just wanted to have props for no reason. That was just tenuously putting those in there for my own entertainment. So some strengths and weaknesses of these. So some of the strengths: judges are impartial and unbiased and ensure procedural fairness to all parties, so that helps achieve the principle of fairness. Judges use active judicial case management to try and minimize delays. Courts also encourage parties to attend mediation or fast track some cases to minimize delays. So they try and get it to be solved before it ends up in court. And the decisions are binding but can normally be appealed. So that's a really good thing because the decisions are binding. They have to go through with them unless it is appealed. Some of the weaknesses of using the courts as dispute resolution bodies is legal representation is generally needed and courts are very expensive. So that's some of the reason why people don't take cases to court, because they're worried about the expense and it might not actually benefit them as much as the expense that's going to occur. Complex procedures mean delays are often cannot be avoided, which means that a dispute you're having now might not be resolved for up to a year or 2 years, and that's a very long time to wait for what's often quite simple disputes, at least in neighborhoods, whereas sometimes the business ones get a lot more complicated, and that can take a very long time. It's not always available as a method of dispute resolution, and parties without access to legal representation are at a disadvantage. So it's often the case that you might not be able to afford a lawyer, so you end up getting a lawyer either through legal aid or anything like that. And chances are, if you are suing a business, they're going to have a very expensive professional lawyer who is going to be very good at their job. Other instances, to promote access, you have like the no win, no charge type lawyers, and they basically, the way they exist, I'm going to be back in a second, the dog wants to go outside. All right, I'm back. Sorry about that, brief delay. So some law centers use the no win, no charge type situation, like you hear about no wiki carbone lawyers and things like that. That they mainly exist. They take on cases that they know they can win, and they take a fair, rather than charging you for the legal representation, they take a percentage of the damages. And as you can imagine, that's probably going to be pretty significant. So those things are good that they exist to promote access, but if they don't think you're going to win the case, they're probably not going to represent you. And that is essentially it. So really, it's about the court hierarchy, knowing the correct order for them, and where appeals can and cannot be heard. Hopefully that's all good for you. It's just essentially, it's one of the painful things that many of these things in legal studies are just content driven. But hopefully you remember those strengths and weaknesses well, and you're able to apply them to situations, and then you will do excellently. On that, I hope you have a wonderful day, and I will see you next time.